Tracy Martin.
Kia ora, Mr Speaker. Thank you very much. I rise to take a short call on behalf of New Zealand First and on my colleague Fletcher Tabato. I also want to join with others in the House to acknowledge the members of the negotiating team that have had what all documents tell us has been a very difficult task. And I can only say that I think it's probably been made even more difficult by having a Minister of Trade, such as Mr Grosser, who earlier today acknowledged that he has no belief that any country should protect its own sovereignty. And I think that was a really interesting contribution from Mr Grosser, that he doesn't believe any nation should insist or have as a bottom line the ability to make its own laws, to actually keep a parliament such as this to create its own future for its citizens to decide what laws it would or would not like to put into place. Mr Grosser believes that those are a tradable commodity. New Zealand First does not. So New Zealand First will stand with the Green Party in opposing this bill. And the Green Party, I think Mr Shaw just expressed himself exceptionally eloquently why the Green Party is not supporting this bill. And certainly I don't believe that New Zealand First would come up with any dispute with the contribution that Mr Shaw made. However, the majority of New Zealand First's opposition is around the ISDS clause, and we acknowledge Mr Goff and Mr Shearer's contribution. We also know that they have no alternative but to stand and support this bill because, as governments, as part of governments before them, they have entered into trade agreements where there have been ISDS clauses. I pointed out, I was sitting on the edge on this particular select committee when the negotiators came to brief the select committee on the completed process, and I asked the question, what had the South Koreans asked for from New Zealand? And all they asked for was the ISDS clause. Now, it's been stated in this House, I think it was Mr Shearer stated it, that he believed that they only asked for it because they like to keep things consistent. That may or may not be the case, but that doesn't mean that New Zealand has to accept it. And I think the other thing that's important too is that when we enter into these trade agreements, there's one set of criteria when you hit the border. So what we're talking about is some tariffs here, and we do note that with regard to milk powder, it keeps its 176% tariff. So that wasn't a great win for that particular industry. But we do note that once you get past the border, there are other barriers that could have been discussed and should have been discussed and haven't heard anything about. For example, the $20 billion of subsidy that the South Korean government gives to agriculture inside once you get past the border. So it's one thing to negotiate a deal and negotiate away your possible sovereignty to actually have some little bit of tariff leverage at the border. It's another thing once you get inside the country. If your government is now all hands off patting itself on the back because it's on this incredible race to try and get to be down in the history books as a government that got the most trade agreements, not necessarily the most high quality trade agreements. So that's one of the reasons why, and the predominant reason why New Zealand First is actually opposing this bill. And I think a very good example of why one should be concerned and look at the fine print and the small details of these sort of agreements is. And an excellent example, I think, is from, let's just talk about the procurement policy of Auckland City. The procurement policy of Auckland City, when it was first created, back in 2011 or whatever, the policy was rewritten. And the local boards lobbied very, very hard for local contractors to be part of or to be given some form of advantage under the procurement policy of Auckland City. And I think a lot of councils do that. A lot of councils, local government, want to make sure that their local contractors have an opportunity to tender, and that if the tenders are balanced financially and with regard to the structure and the content of the tender, that a local contractor is given that little bit of an edge because they know there's local employment, it goes and it moves around the particular community. With regard to the procurement policy of Auckland City, what was most interesting when it was finally written down after all input from community and local boards and so on was that Singapore and Australia were defined as local. So Singapore and Australian companies were designed as local under the procurement policy of Auckland City and would be given the same advantages as any other business inside the boundaries of Auckland. And why is that? Because they're included in trade agreements. Because under the fine print inside of trade agreements, the council could do no other. They could not say that if we have a Singaporean company and an Australian company and a New Zealand company or a company from Auckland putting in a tender for the same piece of work, and the content was the same and the pricing was similar and so on and so forth, they would have been breaking trade agreements. They would have been breaking laws to give advantage to New Zealanders. And that's why New Zealand First stands against these types of agreements. And we will continue to stand against them. It's all very well for Mr Reti, and I see that the campaign for Northland has started up. I can see that isn't it funny how doctors like to be called doctor all the time? Righty-ho. It's very interesting that Dr Reti has decided that, well, obviously he's campaigning for something, although I'm not quite sure what. But it's interesting that the campaign for Northland has begun already. And so Northlanders should be pleased that the moment that Northland elected somebody else who was not a National Party member, you got an awful lot of attention coming from this government. And I would suggest that the best bet for the future is to continue to have a member not actually of the government benches. But if we come back to the bill, Mr Speaker, if we come back to the bill, I just want to quote from Mr Tabato's second reading speech. South Africa, Germany and France are all investigating how to remove themselves either from trade agreements entirely that have investor-state dispute settlement provisions in them, or to remove the investor-state dispute settlement provision itself from their trade agreements. They understand that this is an attack on the democracy and the functioning of their government within their country. They understand that. They have seen the evidence of it, and they are desperately now trying to do something about it. The unfortunate reality for them is that they are beginning to discover that it is not that easy to get yourself out of these trade agreements once you have signed up to them. We are talking about 20 to 25 years' notice in order for those countries to take themselves out of these trade agreements with the likes of the investor-state dispute settlement provisions in them. Mr Speaker, it's too difficult to get out, it's too easy to get in, and what we have also heard today is we've heard people contribute to this House, and again, interestingly enough, from the Labour benches, that while we've had investor-state disputes clauses, we've never been taken to court. We've never had a problem so far. They do, however, appear to be the thing at the moment. They do, however, appear to be the cool thing to put inside of trade agreements. And we've also had some statements, so it's only a matter of time, would be what New Zealand First is saying. And just because something hasn't happened doesn't mean it won't. The other thing we've heard is we've had the number of people who have had to go to tribunals under this, 85% have won their cases. Now, nobody's mentioned the cost to those nations to actually go and defend themselves. Nobody's mentioned the cost, even when they haven't been found to breach or whatever, nobody's tallied up the figures. And what we know is that there are some companies in the world who have more money than New Zealand put together. So what we know is that there are companies there that can take our country to the cleaners because they have more money to throw at an issue than we do. Why would we place ourselves in this situation, sir, is the question. And the relationship that New Zealand had with South Korea was strong enough to create a trade agreement without selling our sovereignty. Perhaps what we need is a Minister of Trade such as the Right Honourable Winston Peters, who actually believes in the sovereignty of the nation, who has the capacity to stand his ground for his country and who is respected by all of Asia.